The Supreme Court is not a trial court. It is not, as the saying goes, a finder of fact. Another way of thinking about that is the Supreme Court does not ask, how did we get here? It does ask what the Constitution says, what a law means, or what the lawmakers who wrote a specific law intended. But it does not ask, how did we get here? Today, the Supreme Court heard case 20719, Donald Trump versus Norma Anderson. Norma is a Colorado voter, a Republican who believed Trump should be removed from the primary ballot in Colorado because he engaged in an insurrection, in violation, according to her reading, of Section 3 of the 14th Amendment. What was the basis of Anderson's claim, later validated by the Colorado Supreme Court? The basis was that Trump, ignoring his own campaign lawyers and attorney general, lied repeatedly about the 2020 election. Further, Trump did nothing while a riot led by his supporters on Capitol Hill sought to delay the peaceful transfer of power on January 6, 2021. Now, was that an insurrection? The Supreme Court wasn't really interested in that question. It was interested in other matters. But of course, that is the why beneath everything. It took more than 2 hours of dramatic Supreme Court oral arguments to ponder a question never before asked in our country's history. Can a state, should a state, remove a former president's name from a ballot because that president rebelled against the nation and its form of government? That's why the court focused on the other question, what to do about it, not so much how we got here. What to do about it, well, that's where we begin today. CBS News chief legal correspondent Jan Crawford and CBS News election law contributor David Becker join me now at the desk. Jan and David, you were both there. Jan, you have 30 years of covering the Supreme Court. This is a highly unusual, deeply historic day among many in the court's history. Your impressions?
Well, I mean, I thought what was most striking is how after those 2 hours of extraordinary arguments, and you outlined it all, the stakes so clearly, how they seem to be, unlike in typically explosive, divisive, contentious cases, how they seem to be searching for consensus. They seem to be trying to find some common ground because they saw problems with the why, with the if we go this way. They saw real problems with allowing a state to say we can kick a president off, a candidate for president off a presidential election ballot. So to me, just watching them as this argument progressed, seeing conservatives and liberals kind of asking the same questions, referring back to the other question, to suggest that states do not have this ability under Section 3 of the 14th Amendment, as you put it, a question never asked before because it's never been tried before. We've never had a former president like Donald Trump before, to suggest that states simply don't have this right. And of course, they played out the impact of it. What if they did allow it? You saw the Chief Justice of the United States saying, I could see a scenario where Republican states would try to kick a Democrat off the ballot, but the Pandora's box would be thrown wide open.
To that point about the practical application of if the Supreme Court did validate the Colorado Supreme Court, let's play Justice Elena Kagan offering some thoughts about that during the oral arguments. Let's run that.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. You know, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, you know, what the Michigan Secretary of State did is going to make the difference between, you know, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation.
That's Jason Murray, the attorney representing Colorado, talking to Justice Kagan. David, it wasn't Alito who brought that up. It wasn't Clarence Thomas who brought the practical applications of this. It was Elena Kagan.
Yeah, and you could clearly see, Jan's exactly right. In Supreme Court arguments, you often have this, through questioning, a conversation occurring between the justices, but it's really hard to tell how those justices might come out at the end. This was not that kind of case. This was unusual. I mean, you had a situation where you could clearly see the justices trying to find ways to shape this argument, and this issue of potential chaos from different state rulings or one state basically forcing all the others down a certain path was something that repeatedly came up in this. And this is why they ultimately, as you know, they didn't answer the why, but they were trying to get to the how and when do these issues come up? And it clearly was troubling for them that this could be a state court issue decided 50 different ways.
And David, you engage on a regular basis with election officials, Secretary of States, and county election officials. Describe for the audience how they are looking for clarity on this question.
Yeah, almost unanimously, they don't really have a strong opinion one way or the other on whether he should be disqualified or not. They might have some emotional feelings about it, but it's not really part of their jobs. They want this to be resolved and resolved finally on the merits as quickly as possible. The primary ballots in pretty much every state have already gone to the printer. They have Donald Trump's name on them, even in Colorado and in Maine. But the issue of whether or not Donald Trump, if he is the nominee of the Republican Party, is qualified to serve as president, and thereby is he also qualified to appear on the ballot in November, is a really important decision that needs to be resolved well before the summer. Not just for those election officials, they need to know how to plan for the election, but for the American people, and honestly for the Republican Party, who needs to know whether or not they have a qualified candidate.
Jen, you mentioned this, and I want to play for the audience. Chief Justice John Roberts talking about a potential tit-for-tat scenario where red states do one thing, blue states do another. Let's listen to that.
I would expect that a goodly number of states will say whoever the Democratic candidate is, you're off the ballot, and others for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Now, whether you or anyone agrees that that would be the natural state of affairs, I don't know if that would be the state of affairs, but it's a hypothetical the Chief Justice entertained.
Well, and the lawyer pushed back on it, said, well, just because these are frivolous arguments. And the Chief Justice went right back at him and said, listen, wait a minute. You may think those are frivolous arguments, insurrection, that's not insurrection, but there are people who will make them. And I thought what was so interesting after that is how Justice Alito jumped in and talked about the very specific example of impeachment. Another issue where, we didn't have an impeachment for 100 years after President Jackson. Bill Clinton is impeached, and since then we've had 3. So once you start down, once you open that box, we can't assume
Andrew Johnson
that
impeached
this is the one-off.
long period of time before Bill Clinton.
Yes.
But the significance of the Chief Justice bringing that up and your role, do you think, Jan, in the next week or two as this opinion comes together?
Well, I think they're going to do it. This has been fast-tracked. This is a special argument during what should be their winter recess. They know the time constraints here. They know Super Tuesday. As David pointed out, ballots have been printed or being printed. Super Tuesday is less than a month away. They'll do this quickly. And, will it be within
the Chief Justice will look for consensus.
He's going to want consensus. I think that actually, though, what we saw in this argument was that they all want consensus. I think the court really recognizes this is a moment for them to show they are above politics. The court has really taken a hit. Look at the polls. They're almost right down there with, the media. No, a little higher than that. They're still higher than Congress. But, it's really taken a hit. And if you look back to Bush versus Gore, which I covered, that was a case that was not a good moment for the court. It was not the court's finest hour. 5-4, the conservatives giving the presidency to George W. Bush, the liberals siding with Al Gore. This is an opportunity for the court to come together, and we'll see if the Chief Justice can do it. But I thought today what was most striking about that argument was how they did appear to be on a divisive issue involving a divisive person trying to find common ground.
And David, of course, Bush v. Gore was about a question that was legitimately discussable within a court of law. What was voter intent? Did ballot design and other methods create confusion about genuine voter intent? This is different. This is about past behavior disqualifying you from a future ballot.
Right. That was a really well-litigated case on both sides about a statewide election decided by 537 votes. Really close election. But this is a different situation. We're ahead of the election. We're deciding on qualifications. Can this person run for and serve as president? And I think one of the challenges, while the court might be finding consensus and that they might be helping the institutional credibility of the Supreme Court, perhaps with something even like a unanimous verdict here, this in some ways could very well still kick the can down the road for a political problem, especially on January 6th. If
January 6th, 2025.
2025. So if, for instance, the Supreme Court rules, as I think Jan and I think they both are likely to rule, that the states cannot independently, without congressional authorization, disqualify a federal candidate or the president from their ballot, then what happens if Donald Trump wins in November? And he has all the electoral votes to win, but on January 6th, Democrats in Congress challenge those and say he's not qualified, not because he was the states didn't have the power, but because he actually engaged in insurrection. That would be a political argument and could create chaos all over again. So there's a potential here for kicking the can down the road that could be problematic.
And then, once again, whether the country wants to or not, it may have to confront what is the actual applicable definition of an insurrectionist. David Becker, Jan Crawford, thank you so very much.